Diesel Weeds People News. Okay. Um, we also need to start making a glossary page. Okay, definition words, definition person, definition people, definition man, and send this into the courts. Okay, and just ask them to answer these questions. Um, what's the lawful money or legal money or Congress? The only authority they have is gold and silver. According to Congress, the states can only operate in gold and silver. So if anybody's asking for banknotes, dollar bills, credit, and all that, that's unlawful. The states must actually uh, comply with the Constitution of Congress of gold and silver. Even if the federal government don't use it, the states must use it, and that's the people as well using it to conduct business in each state. So we need to clarify on a glossary, okay? And which brings me back into this, right? I do have a video about that a few videos back about the glossary and understanding the Article 1, USC 1, how up means down and down means up and girl means boy and boy means girl, as you can tell in this day and age. Alright, so I'm going to let you just listen to this.
Try again. You know, being involved in many of court cases, I've come to realize that we always want to set up a perfect affirmative defense for an appeal. And if we don't do that, we fail to set a proper record and set the appeals record for the appellate brief. If we don't do that by reserving our rights and objecting timely and taking exception to it as an appealable issue and noting it on the record, so often we fail. And we don't just fail ourselves, but we fail our fellow countrymen. Remember, when we prevail, the people prevail. Okay, so keep that in mind. This is written in a way that it's kind of hard for me to read because my brain is trying to process ahead of the written instrument here, and it's not always written in a fashion that my brain processes quickly. So if I stutter my way through this and stammer through it, please forgive me. Is this a court of record, of competent jurisdiction? And that question is very important because we want to know that this is a court of record, all right? Is this a judicial proceeding or an administrative proceeding, all right? There's different rules to judicial proceedings versus administrative proceedings. If no, what are you convening? What venue is this? All right, where are we at? Are we in legal land where Puff the Magic Dragon can come in and blow on Jackie Draper's ear and create Jackie Paper? Are we in reality or are we in fiction? Okay. What is your jurisdiction? Aren't there two types, personam and subject matter? Okay. And, we want to know if we're in concurrent jurisdiction, auxiliary, or exclusive. Are they blending all three under the Judicature Act of 1875? Now, this might be a little advanced for most people, but these are all relevant points and questions to ask. And if you ask this series of questions before you get started, the chances are that you're going to receive something in the mail that says the sua sponte, upon the decision of the court, the state has not met its burden of proof to proceed, and therefore this court dismisses said action, okay? And remember, by asking these questions, we can expose the truth by their admission by omission, their failure to clarify, their failure to accurately record on the record what's true, correct, accurate, not misleading. By asking the questions, the devilish tricks of the lawyer go out the window.
Absolute, vague, ambiguous, absolutely.
3. Judge, is your oath of office a contract? Yes or no? Okay, I always tell people you've got to accept the oath of office because it is a contract. At the time, it's a contract that they have entered into as equity imputes an intention to fulfill an obligation. However, equity will not perfect an imperfect gift, meaning that if you don't acknowledge and accept their oath of office, it's an open ended contract. And if you haven't accepted and acknowledged it, then it doesn't apply. So make sure for and on the official record, in a judicial notice or orally, that you accept and acknowledge the oath of office of the judge. How many oaths of office are there? There are a multitude of oaths of office. There is the Title IV 101 oath of office.
And that right there, people, that absolutely does not have that. I've looked and looked and looked, and everybody, your police officer is supposed to have it, CPS is supposed to have it, everybody's supposed to have this, okay? And by the way, this is the first Congress, okay? It's supposed to be with the full legal birth name.
There is the Title V 3331 oath of office, which is their private for-profit oath of office, where they're operating an Admiralty Maritime under the UCC to negotiate securities, financial instruments, okay? So I accept and acknowledge that as well. There is the Title 28 455 oath, 453 oath of office, and I accept and I acknowledge that one as well, okay? Then there is the constitutional oath of office pursuant to the Constitution for the United States of America. I accept that as well. And then there is the state constitutional oath, and I accept that as well, okay? So we want to make sure in a judicial notice that we accept and acknowledge all of those oaths of office, and I go as far as to pull them up, and I supplant their full legal name, if I can find it, anywhere on public record. I supplant their full legal name in the section where it says IAB, which is where their name is supposed to go, and I put them on judicial notice of the acknowledgement and acceptance of that oath of office, and I bind them thereto to protect my unlimited, indefeasible, unalienable rights, both written and unwritten, okay? I don't see where the person administrating your oath had an oath on file and or recorded and filed his copy of your oath. It is incumbent upon you, ladies and gentlemen, to ensure that you demand their oath of office be put on record for your inspection, not just filed in the case file jacket. There's this egregious misconception that if a document has been filed with the clerk of the court, that it is on the court record, okay? You want to get it recorded onto the court record for your inspection, all right? And if the oath is not proper, well, then there isn't an oath. Now, people say, well, how do you hold them accountable? I use the maxims in equity to hold them accountable. Equity imputes an intention to fulfill an obligation, meaning that the second they received a paycheck, they were bound by the intent of the organic constitution and the oath prescribed that they are supposed to have, okay? And so I bind them in that manner. And remember, if you fail to acknowledge and accept their oath of office, and in doing so, equity will not fulfill an imperfect, or equity will not perfect an imperfect gift. All right, so you have to acknowledge and accept. Number 4, judge. Why don't I find a bond? We require their good faith bond be placed on the record for, again, our inspection, okay? They don't have their bond on record for our inspection, it is as though it doesn't exist. Remember, this is a very controlled environment. We want to keep everything that gets put on the record very sanitary and clean-like for our inspection purposes, okay? We're not...
Also want to iterate that you want to ask about the Foreign Registration Act of 1938 for hearing on the record.
qualifying their bond. It's for our inspection purposes. The bond is going to tell us who the surety is, who the principal is. It's also going to give us a plethora of information on how to contact the managing agent of the bond so we can make a claim. Okay, a bond is just a fancy word for insurance. Okay, who is your insurer? A lot of times it will be different companies, mostly I find that are out of Delaware, like for example, the Ohio Insurance Company. Sounds like it would be located in the state of Ohio. However, upon further inspection, Ohio Insurance Company is actually out of Delaware. 5. Did the judge sign the correct oath, not impartial? File his oath into the case. Again, if you can't get them to provide their oath of office freely of their own free will and volition, which is kind of deceptive, what you can do is you can hit the judge with a FOIA, okay? Freedom of Information Act. You can hit the clerk of the court, the secretary of state. In every state, it's a little different, but they do this intentionally to cause mass confusion. So people don't necessarily know where to find them. Sometimes you find the judge's oath at the county recorder's office. In other states, you will find that the clerk of the court has them. In some states, you will find that the secretary of state has the judge's oath of office. All right? We want to pay peculiar attention to all documents. We want to make sure that everybody is using their full legal name to sign the oath, okay? And that they're not using a pseudo name. And if they are using a pseudo name, for example, first name, middle initial, last name, then we want to make sure that on the county record they have that assumed business name or trade name filed on record. And you can find that at the county recorder's office or the secretary of state's office. If you can't find them in either location, you need to put the judge on notice, or anybody for that matter using a false or fictitious assumed unregistered business name that you cannot locate. You want to put them on notice that you demand they produce said assumed business name or trade name for and on the official record for your inspection. This is about holding people accountable and liable for their actions and making sure that you can be compensated for their unjust enrichment or engaging in simulated legal processes using sham legal pleadings without being able to provide a bill of particulars as to the nature and cause of action that they're attempting to subject you to. Okay? 6. Judge, is your oath I have here, did you swear an oath to uphold the Constitution? Which ones? Now, the reason they ask for which ones is after the Act of 1871, there are two jurisdictions running concurrently at all times. You have the de jure, and then you have the de facto. And it's important to understand that there are a multitude of constitutions out there. Michigan, probably one of the most confusing states that I've ever evaluated. And in Michigan, if my recollection serves me proper, they have flat out created a brand new constitution at one point. I think over 6 or 7 constitutions have been manufactured, and it's always funny because they say by the consent of the people, the Constitution has been amended, but they didn't amend it. They just flat out rewrote it, which I found extraordinarily interesting, and asked the people of Michigan, when were you ever asked whether or not you would allow them to just rewrite the Constitution and bind you to it? So you have to invoke the proper Constitution, which is the organic Constitution in each state. You invoke it. You invoke your unalienable rights. You invoke the Bill of Rights. You invoke, if you so choose, the Law of Nations. And you bind these people to it. All right? 7. Will you judge?
In Texas, I believe, geez, I might kind of sit and think about that, and I paused it way too early. Was it Article 3? And then it's Section 29 up to 38 that basically says that, our legislatures in Texas cannot do these things.
sign any contract that guarantees that you will protect all my unalienable rights that are protected by this country's Constitution and, in this instance, Washington State's constitutions. Okay, and again, you're going back to the two constitutions of Washington State. You see one here clearly in 1878 and 1889. Again, I like going with the organic constitution, with the meat and the substance on the bone still. All right, the intent of the testators, because all constitutions are in fact trusts. Okay, and to prove that, you just simply have to read the preamble. All right. 8. Do you intend to process this case according to the Constitution? And when we ask questions, we just want to ask one simple question, get it on the record, make the observation on the record as to the answer. If the answer is not sufficient, we're going to ask for clarification and get them to explain further finding of facts and conclusions of law on the record to ensure that all real parties of interest are fully informed, pursuant to due process of law. They're going to get very annoyed about this because they like to run sheep through their little fucking chutes and run them through as they wager on the ignorance of the people. So they're going to get very hostile, very annoyed. And if they are starting to yell and stammer around like the little devils they are, it's always a good thing to put on the record. Is there a reason you're being hostile today, Your Honor? Is there a reason you're yelling at me? Is there a reason you're scolding me? This seems like it possibly could be contrived to be seditious behavior or behavior unbecoming of a judge that might lead to insurrection. Is there a reason that you're hostile today? And by asking these questions, okay, you will notice the demeanor of the people sitting on the bench will change very, very quickly.
And we're going to go ahead and end it there, people. And it was just a taste. And this is where the storm clouds are gathering. Okay, it's Derek Gonzalez. Okay, he's got a really interesting YouTube. So if you want to check out his YouTube, see more of all the way through this list, or if you guys want me to do extended version, which sometimes I do without your consent, just leave me a comment on there and I'll do a couple more to break this down. Okay, because his is an hour and 20 minutes long. So this way the people knows. Always ask questions. Because if you don't ask questions, then you're never going to get answers. And if they don't never give you answers to the questions you ask, then they're in silence or acquiescence, and they still tacitly agree to your terms. These are the people news. Bye, y'all.